Our court case is the Savana versus Redding court case. My name is Brandon Bleuel, and this is Easton Baker, and we are representing the great state of Arizona in the Safford School District, and we believe that this court case is not a violation of the Constitution due to the reason behind the search given to Savana Redding by the Safford school officials. Here are the true facts of the case on the day it happened. On January 26, 2009, Savana Redding was strip searched by school officials at Safford Middle School in Safford, Arizona. School officials were tipped off by some of Redding's peers, and Redding agreed to the search of her backpack for pills, other drugs, or any specifically prohibited drugs. But the main suspicion was that she was carrying ibuprofen with her. They had a reason to believe that Redding was carrying ibuprofen due to another student claiming so. Carrying ibuprofen or other pills is not allowed by Safford on school campus. The school officials were informed that by a friend of Redding that the pills that she had been found with earlier in the day were given to her by Savana. She was eventually asked to be searched, and she agreed to the searching of her backpack. Then she went to the nurse's office and was asked to take off her clothes and shake her bra and underwear, but not completely remove it in order to see if there was any hidden drugs or other hidden substances she was carrying. The morning of her search, one of Redding's classmates was pulled out of her class to be searched herself, which revealed a knife and other pills. Her classmate told the officials that they were given to her by Redding. That is when the search occurred after that in the nurse's office, and then at the end, Redding was pulled into the assistant principal's office.
The people of importance in this case are the victim, Savana Redding, who is the one searched by the school officials. Her significance in this is that she is obviously the victim in the center of discussion in the court. She is the daughter of the petitioner, April Redding, who is the mother of the victim. She is the one who brought this case into existence because she was not okay with how her daughter was treated at the school officials, and that it wasn't okay for her to be searched like that, and she said it was violated the Fourth Amendment. Carrie Wilson is another person of importance, the assistant principal at Safford Middle School. She's the one who asked Redding to go to the office and showed her the pills that were found on her classmate and questioned her about them.
Another part of this case on the school side is Penny Schwaler. She's the school nurse at Safford Middle School. She's one of the two people who asked Redding to remove her clothes and then asked her to shake her bra and move her waistband of her underpants in order to reveal if there was any other substances she was carrying. Some important items are the drugs and prohibited items. They were found on Melissa's pier, as well as this is what was being looked for when they were searching Redding on this day. Another important item is Savannah's clothes and her backpack. This is what was searched as they asked her to search, and she agreed to have her backpack and her clothes be searched by the school officials. Another member of the school's staff is Helen Romero, who was an assistant to the assistant principal Wilson. She was a bystander and a witness of the events of the stripping and the searching of Savana Redding. She was right there when it happened, according to sources, and she is a member of the school and part of the respondent to the case. Melissa's peer, Marissa Glines, she was the one who was previously searched earlier in that morning and led to the reasoning and suspicion for Savana. Without her, they would not have been tipped off or had a reason to search Savana later that day. The legal precedent is that they must violate the Fourth Amendment in conducting a search and seizure that is considered by Constitution to be unreasonable.
The history part of the Constitution, why did the framers feel compelled to protect us in this manner? To avoid situations such as these that involve uncomfortable situations, especially for young people, where she was forced to strip all the way down just due to a suspicion, which was clearly false. This was out of order and not okay, is what they stated. The framers wanted to protect against searches that were unnecessary and may have been done simply to antagonize. Why is the amendment significant? The amendment is significant because it prevents people from searching simply for fun of it. They need a valid reason to search you and can't do it on a whim. A reasonable search if someone is tipping that the person that is being searched as illegal items like guns and drugs.
The legal precedent of this is the case of there are many cases that form the legal precedent for the the case leading up to the Safford versus Redding cases. There are 6 cases that uh, had the Fourth Amendment in question. The Fourth Amendment, which involves searches and seizures and quartering acts. Some of these cases, the first one is Terry versus Ohio. Terry was with 2 other men, and all 3 were stopped and searched. All 3 were found with firearms. The policemen arrested them instantly, and Terry was then convicted for 3 years, for 3 years in prison. The majority for this which was delivered by Earl Warren, was an 8-1 decision in the favor of the not in favor of Ohio. It was that the search was reasonable and did not violate any parts of the Fourth Amendment, and the Fourth Amendment was actually used against them in court as a reason they could use firearms for the evidence against Terry. What is the precedent? How does this support what we're talking about today with Safford versus Redding? This supports our argument because Terry and all 3 men had firearms on them, and therefore they had suspicion, and it was a reasonable search. And this is similar to what happened here because they were tipped off about Redding, and that gives them a reason and a suspicion to search Savana Redding. Another case is Katz versus United States. This was a case where Katz was relaying sports gambling information over the phone to other people in different states, which is against federal law. He was giving this handicapping information, and they were tipped off by this and used a tracker outside of the phone booth in order to track his conversations and eventually convict and arrest him. However, Katz argued that this tracker was illegal. They weren't allowed to put the tracker near the phone booth, and in court, the favor was actually ruled in favor of Katz, 7-1. Another case that involves Fourth Amendment is Payton versus New York. New York suspected Payton of murdering a gas station owner and the manager. There was evidence, and it was introduced at the trial. But when they entered his home and they didn't have a warrant, this was what he brought up and fought against, and they actually ruled again in the favor of the victim and Payton. In a 6-3 vote, they decided that there was no warrant and it was an unlawful. They didn't have a reason to search his home, so that it was unlawful, and Payton won this case.
Another case example is the city of Indianapolis versus Edmond, which is when Indianapolis started to begin operating vehicle checkpoints in 1998 in an effort to intercept unlawful drugs. At each stop, one officer would look through the car with the other officer brought out a dog to sniff out narcotics in the vehicles. Edmond was stopped at one of the checkpoints, and after the checkpoint, he filed a lawsuit that the checkpoints violated the Fourth Amendment of unreasonable search and seizure. The opinion was delivered by Sandra Day O'Connor on a 6-3 decision, and they came to a conclusion that it indeed violated the Fourth Amendment.
The next case is Arizona against Gant versus Gant. Gant was being searched by the police. His house was being searched by the police when they found 2 people who weren't Gant inside of his own home, doing illegal things, and were held in possession of crack pipes. Gant pulled in the driveway while the police were at his house, and the police immediately searched his car and found drugs and arrested him. In favor of Arizona was the vote. They ruled in favor of Arizona because they were allowed to search his car because the evidence they had already found in the house was a reason and a suspicion that Gant might have been violating some laws and be in possession of firearms or other things. This is a reasonable search and seizure, is what they ruled. The precedent for this case was New York versus Belton, and this was the precedent that kept this case in ruling and gave way to this case.
Another example is the Michigan Department of State Police versus SITS. Michigan set up sobriety checkpoints to try and reduce drunk driving in the state of Michigan in 1986. SITS challenged the checkpoint. He sought out declarative injustice relief. The majority opinion was delivered by William H. Rehnquist, was a 6-2 decision that did not violate the Fourth Amendment of unreasonable search and seizure, because no one can really dispute the magnitude of drunk driving. And this is very important because you can't stop it. It's just something that you have to check and find, and that's not fair to people that aren't drunk or driving, because it's not reasonable for them to search them.
School policy says that you can't have any type of drug, including ibuprofen. They found stuff on Savannah's friend, and that was proof that there were drugs circulating around campus, or at least somewhere on campus. And this gave them a reason to go to what they believe at the time was the source in Savana Redding, as she was the one who was reported by her classmate to be spreading out these drugs to people. Since they found the stuff that violated their rules, it was a reasonable search and seizure of Savannah Redding in the nurse's office, since she was stated as the source of these drugs. Uh, Another thing is a warrant and agreement to search and seizure. Redding agreed to the search of her backpack and clothes. So before the school officials began to search, and even though they did not find anything that would make Savannah uh, liable here, they had a reason to search her, and she granted them authority, which makes it a reasonable search of her. And had they not had an agreement, then you could argue this is an unreasonable and it was a forceful search. But she agreed to not only having her backpack, but also having her clothes searched by the school officials.
The court ruled in favor of Redding, saying that they did not have the right to search and seize her because of their suspicion of drugs. Argument is that it was not a violation of search and seizure due to reasonable search. Court ruled in favor of Redding in real life, but we believe our argument that the evidence was found can go against the real life ruling.
Some more background about the Safford School District is that the policies in it prohibit the non-medical use, possession, or sale of any drug on school grounds. This includes what Savannah Redding was under suspicion for, which is ibuprofen. The ibuprofen was not found on her, but since they had that suspicion, they had a very reasonable reason to search her and to make an investigation about her, considering what they had found on her on Melissa Grimes. Ms. Redding permitted an assistant principal, or the assistant principal, Carrie Wilson, to search her belongings. However, when the search did not produce any pills, the assistant principal directed an administrative assistant to escort Redding to the nurse's office. In the nurse's office, this is where Redding was. In her case, she claims that she was. They made her strip down, and eventually her bra underwear where she was like shaking them in order to prove that she was not carrying any drugs, which she did prove. She did not have any drugs on her or any other prohibited items that she shouldn't have on school campus. But her mother, a few months later, filed a lawsuit against the school district and the officials that were involved in this strip search, saying that the Fourth Amendment rights were violated. However, we believe the Fourth Amendment rights were not violated. This is in the Constitution, the Fourth Amendment states that when you conduct a search and seizure, for it to be a violation of the Constitution, it must be an unreasonable search and seizure. However, due to our evidence of her not only agreeing to it, but also there being somebody found with drugs, it leads to the suspicion of her, and it leads directly back to her, that this is a completely reasonable search and seizure. However, on appeal, on U.S. Court of Appeals, they affirmed a rehearing. The hearing and the eventual verdict in the real life case is that the Fourth Amendment rights were violated, and the court ruled in favor of Redding. However, we are arguing against that due to the fact that this was a reasonable and not unreasonable, as they said. They believe that the school officials were protected from liability by qualified immunity. The analysis is that the Fourth Amendment establishes the right of the people to be secure in their persons against the unreasonable searches and seizures. The Fourth Amendment standard is that reasonableness that stops short of probable cause, and the measures adopted for a school search have to be reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. So with that quote is saying that it has to be an objective of the search to find and not to like harass, which is there's a completely valid reason with the fact that her friend was found with prohibited items and that she very well could have been the one distributing them. So that makes it reasonable search and seizure. The official searcher had sufficient suspicion to justify a search of Miss Redding's backpack and outer clothing, because a student had told her during the prior week as well as the morning of that students, including and mainly Savana Redding, were bringing not only just drugs and ibuprofen and what was suspected, but also firearms and weapons to school. And because another student again, just an hour earlier that morning, accused Miss Redding of providing her with the pills that she was found with. This creates a reasonable search and seizure. So we believe that our argument is enough to overturn what the ruling was in real life that made Savana Redding guilty. Or made Savana Redding was found innocent, and the school was found guilty of the wrongful search and seizure. And that's all we have. Our sources were Oyez, Law Cornell, and Wikipedia.
Thank you.